Good afternoon, everyone. My name is Maya Luria with TMC for Seniors, and we are continuing on with our Healthcare Decisions Month. And we are going to be discussing legal documents you should have a comprehensive overview. Many of you may know Shanelle Schmitz. She is here with the Law Office of David Karp. Shanelle, you always provide so much information. I know this can be a topic that is really hard for to sort of break down. And so I'm excited that you're going to be able to sort of give us a big overview of all the different types of documents so that people can make the choices that they need when, putting their legal issues together. So welcome. How are you today?
Thank you. Great. Thanks for having me, and welcome everyone. Thanks for coming. So as Mike was saying, my name is Shanelle Schmitz. I'm an attorney here in Tucson. I focus my practice on estate planning, probate, and trust administration. Our office does do some elder law as well. I did used to do a lot of contested cases. No longer doing the contested cases, now focusing more on the planning to try to prevent court. So I did include my contact information here, and for those in person, I do have some cards over there. Feel free to reach out if you have any follow-up questions after this presentation today. And so I'm an attorney, so of course I'm going to have a legal disclaimer. Anything that's presented in this PowerPoint shouldn't be construed as formal legal advice, nor the formation of any attorney-client relationship. If any results are set forth herein, such results are based upon the facts of that particular case and do not represent a promise or guarantee. It's always important for you to consult with an attorney about your specific case, because everything is based on your specific situation, your family situation, your assets. So whenever an attorney meets with a client, we're looking at all of those things whenever we're coming up with an estate plan. So what I'll go over today is just general information on the different types of important legal documents. So what I plan on covering today is, first we'll talk about healthcare directives. So healthcare directives is usually going to be a healthcare power of attorney, living will, HIPAA authorization, the general financial durable power of attorney, will or pour over will and trust, and then some key information on what you can do to help your family and friends, your loved ones, be prepared if something does happen to you. That way they're able to take care of you if you become incapacitated or manage your estate upon your death. So a healthcare power of attorney. So this is one of the most important documents, and everyone in this room should have one in place. So a healthcare power of attorney is where you can nominate who is going to make healthcare decisions for you if you're not able to do so yourself. Now, a lot of clients come in and ask me, does it have to be my spouse, or does it have to be based on birth order, my children? And they'll kind of go down the list. And what I like to advise is it needs to be someone who you're comfortable with making those hard decisions about your health. You want to make sure that they're willing to make the decisions as you want them to be made. So if it's more important to make sure that if you're naming a child, that it's a child who can handle that responsibility versus going based on birth order. And it does not always have to be your spouse. Sometimes spouses have a very hard time making those decisions. So maybe you don't want to have them as the first agent. But the most important thing is to pick someone who can make those decisions for you, and to let them, to make sure they understand what decisions you would want to be made for you when you're not able to speak for yourself. Also, some people ask about what happens if you have no family or friends who you trust. Then there are other options. So there's professional licensed fiduciaries who do serve as healthcare agents. So that may be one option that you can look into if you don't know anyone who can serve in that capacity for you. The healthcare power of attorney also allows you to nominate a guardian. So the idea is, if you have a healthcare power of attorney in place, you're trying to avoid a guardian. A guardian is where the court appoints someone to make healthcare and placement decisions on your behalf. However, sometimes there are situations, let's say maybe you have family members who don't quite get along, and your agent and a family member or another family member is causing trouble at the hospital. Now the hospital may end up requiring a guardianship. So it's important in the healthcare power of attorney to nominate who you would want to serve in that capacity if a court-appointed guardian were ever to be needed. In our documents, we also like to specify who do you not want to serve as your guardian. So if there's certain family members who you would never want to make healthcare decisions for you, we do add special language in there, basically saying it's your wish that these persons never be appointed as guardian. That way, if they ever do make an issue in court, now there's documentation saying that you never wanted them to serve. So the court has that evidence, basically that it was your intent that they not be ever appointed as your guardian. So you can also include funeral and disposition arrangement authority in your healthcare power of attorney. So if you don't want an autopsy, you're okay with them making the decision to have an autopsy, organ donation. So this is something really important to think about, whether or not you want your healthcare agent to be able to make donations on your behalf. And in our documents, we also specify if you have a preference between donations for transplantation only versus medical research or any legal purpose. So those are things to think about, and you can specify in your healthcare power of attorney. There's also a mental health care power of attorney as well. So for mental health powers, so essentially your healthcare agent can make all decisions regarding your health and your placement, including mental health treatment, except placement in a locked psychiatric facility longer than the minimum or the mandatory hold. So it's 48 to 72 hours, depending on if there's a weekend. And if you're needing to be placed in a locked psychiatric facility longer than that, basically to get stabilized, then you could either have a mental health power saying that your agent can move forward with that, or else they have to petition the court, and now there's court oversight. So that's something also to think about when you're filling out a mental health power of attorney, whether or not you want your agent to have that authority, or if you would prefer court oversight in that situation. So those are the important key points on a healthcare power of attorney. But like I said, everyone in this room really should have a healthcare power of attorney.
Is that the same as advanced directive?
Yes. So there's a lot of different terminologies you'll hear, but yes, a healthcare power of attorney is part of what you usually hear whenever people refer to advanced directives. Living will is also included in that. Yes.
I'm surprised to see that you can make a choice about autopsy, because I thought if anything might be questionable, you have to have an autopsy.
So,
you know what you're saying.
So this is really just saying whether or not you give your agent authority to make to allow for an autopsy. If there's a crime, then things obviously are going to be different in that scenario.
Or possibly suicide.
Yeah, I mean, it's going to depend on the scenario. But this allows for your healthcare agent to make the determination. Let's say there's not crime or suicide or anything like that. They could still make the determination to have an autopsy performed. So that's something to think about, whether or not you want to give them that authority and what your preference is. Most people don't really have a preference, I find, but sometimes with, if you have certain religious preferences, you might want to not allow it. It just depends on your personal situation.
Can I ask you a question about that? In hospice, there's something called voluntary.
Maureen, can we save it for the end?
Sure. So we can get there.
Yeah, we'll definitely save time for questions at the end. So the next document is living will. So this is instructions regarding your level of care, and it usually deals with extraordinary measures. So basically, whether or not you want life-sustaining treatment beyond comfort care, if you were terminal in an irreversible coma, persistent vegetative state. So let's say you were brain dead. Do you want to continue life-sustaining treatment if it's only going to prolong the moment of your death, or do you want to die naturally? So there's also language in there where you can have a pregnancy override. That way, if you ever did become pregnant, it could be overridden. That way, the baby can continue growing full term. So this is different than a do not resuscitate order. So a do not resuscitate order needs to be signed by a physician or healthcare professional. So this is not saying do not resuscitate. So if you're in an emergency situation, that's an orange form. You'll hear about, putting the orange form on your refrigerator, that's different. That needs to be signed by, usually it's best to have it signed by your physician. And that's in the case, most people don't need a do not resuscitate order unless maybe they're on hospice and they don't want to receive CPR or any kind of life-sustaining treatment if there's a medical emergency. And then we do a separate HIPAA authorization at our office. The reason why we separate it is because, so HIPAA authorization, I'm sure you've all heard of HIPAA rules. Essentially, it allows for people to have access to your healthcare information and healthcare records. So let's say you're hospitalized. These would be who would be able to access information about your condition. We like to have two separate documents, but you can also have it in your healthcare power of attorney as well. The reason why we do a separate HIPAA authorization is sometimes our clients want to add people who do not make the decision, but they want them to still be able to call the hospital and get information. So sometimes it's important to have that separate HIPAA authorization. So practical considerations for healthcare directives or healthcare power of attorney living will. So here at TMC for Seniors, they provide assistance with filling out healthcare directives. So if anyone in this room doesn't have them, I really encourage making an appointment so that you can get those filled out. The Arizona Attorney General's office also has free state forms, so you can download it. It's called a Life Care Packet. And I included the website here. There are a lot of instructions involved. So if you're not working with an attorney and you have questions, like I said, TMC for Seniors can help you fill those out. But it's really important for everyone to have a healthcare power of attorney in place. Another important practical consideration is if you do have any medical issues, if you're on any kind of medications, have any kind of allergies, consider keeping everything together in a binder. What I sometimes recommend is kind of like a trapper keeper where you can put in important medical records, important information on any kind of allergies. That way it's easily accessible for your family members. That way, if there is an emergency, it's all together and now they have whatever information they need. And of course, let them know about it. Make sure they know and they're aware. That way it just makes it a lot less stressful for them and that type of, because it's going to be stressful acting as someone's healthcare power of attorney. This helps alleviate it because now they have the necessary information that they need. There's also an Arizona Healthcare Directives Registry, and I put the website up here as well. So a lot of times people aren't carrying their healthcare power of attorney around with them. So most people don't have it in their car with them. So if you're in a car accident, it's not going to be accessible. So the Arizona Healthcare Directives Registry is one place where you can upload them. And the idea is the hospitals can get access to your healthcare directives. There's also private companies. So our firm uses what's called DocuBank, where you get an emergency contact card for your wallet. It'll have specifics. So let's say you do have medical allergies, anything like that, you can state that on the card, and then it has information so that the hospital can access your healthcare directives that way as well, or your agent can access. So something to think about, you want to make sure that your healthcare directives are accessible. So even if you don't do either of these things, at least give your agents copies. That way they have them if something were to happen to you. Okay, so the next document is a durable financial power of attorney. So this is only effective while you're alive. It is no longer effective upon death. So that causes a lot of confusion among people. So just want to point it out. This is only while you're alive, and it provides disability protection. So if you were, let's say you were in a car accident and you were no longer able to pay your bills, a durable financial power of attorney would allow for an agent to step in and manage your assets for you. We recommend having very broad powers and making sure whoever it is that you choose as your agent is someone who's trustworthy. That way they can step in your shoes and make whatever decisions are needed. So ours are, like I said, they're very broad. Ours are about 25 pages long. Some of it is big print, but it is, we do end up adding a lot of extra powers in it just just to make sure that your agent can step in your shoes. There's also two different types of powers of attorney. There's what's called springing and what's called effective immediately. So springing is only effective if you meet certain qualifications. So let's say you're incapacitated, and sometimes what I see is you need an opinion from 2 licensed physicians that you're incapacitated so your agent can act. That's springing. For effective immediately, it's effective right when you sign it. So we generally recommend effective immediately because the idea is you choose someone who you trust. That way, now they have that power. They shouldn't be acting without your permission if you have capacity, and they can get in trouble for that. So they can be criminally liable if they are acting against your will and you have capacity. Now, it is a great responsibility and liability for the agent. One of the issues with powers of attorney is they're not always accepted. So with a lot of banks, they have internal policies where if they're older than 2 years old, they won't accept them. So it's very important to keep an updated, durable power of attorney in place. Another thing I recommend to clients is if you have accounts, let's say you have accounts at Chase or Wells Fargo or whichever bank it is, usually they have their own power of attorney form for specific accounts. So you can do their power of attorney there. Now it usually only applies to those specific accounts, but now at least they're going to be less likely to reject their own form versus another power of attorney that they receive. And the reason being is they have concerns about liabilities. So let's say your power of attorney is 10 years old. They would be concerned that you've updated or you've done new ones since, so they won't honor it. So in that case, you may need a conservatorship, and that's appointed through the court. So it's just a good idea to keep these documents updated. We recommend to our clients to try to do it every 2 to 3 years. Yes.
What does it require to update this document? What's the requirement? Just to change the date?
If you have no other changes, then that works as well. A lot of times there are specific law changes, so we're adjusting the powers when our clients come in 2 to 3 years. But if there's nothing else that needs to be changed, then it's literally just re-signing it, redating it.
And that can be done with a notary public?
So you have to have a witness and a notary. So a witness who's not related or who's not going to be the agent, and a notary.
We'll do questions at the end. You guys
Yeah,
all
keep all your questions, and I promise I'll stay for a while so that we can answer your questions. Okay, so some practical considerations on general durable power of attorney. So again, the most important thing is picking someone who you trust as your agent. So we also recommend having multiple successor agents. So usually we're recommending to our clients to have at least 3 and have it one, then so first, second, third in that order, rather than having multiple listed who can act at the same time. The reason being, let's say you had 2 children and you wanted them both to be able to act, and you put them acting together. Sometimes that causes issues. Sometimes, let's say one lives out of state. Now they both have to go to the bank and sign something, might cause a delay. Also, if they don't get along or there's a disagreement, then it's going to likely end up in court. So that's why we always recommend just having at least 3 if you know 3 people, and then having it in order 1, 2, and then 3. So the other important thing for your agent is to have a list of assets and contact information for any advisors or professionals who you work with. So let's say you have a financial advisor. Definitely want to have that information readily available for your power of attorney. That way, if they do have to step in and manage your assets, it's easier for them to gain control and to know where to go. So a lot of times, we run into this issue if someone didn't do a lot of preparing beforehand, where someone comes to us and they need help trying to figure out where all the assets are. There's not a general registry that we can just type your name in and find out what banks you bank at. So there's a lot of investigatory work that has to go into that. So we recommend just trying to keep a list. Now, you don't have to provide it to them now. Most people don't want to let their agents know what their assets are right now. You could if you're comfortable with that, but at least have a list of it so that it's accessible. And even if you don't specify the amounts, it's helpful to say where you bank, where you have different accounts. That way they have that information. And then also if you have like a CPA, tax preparer, and I just listed some of the general assets you would want to make sure to have on that list. And then another thing is monthly bills. So nowadays, a lot of people get their bills electronically, not mailed. So it used to be easy. You would just monitor someone's mail if you're trying to figure out what needs to be paid. Now that everything's electronic, it makes more sense for you to have a list of what those monthly bills are. That way, if an agent steps in your shoes, they know what bills need to be paid. Okay, so the next document, so a will is effective only upon death. And so a will is essentially instructions to the court as to how you want your assets to be distributed. So in order for it to be effective, it has to go through probate court. So a lot of people misunderstand that. So keep in mind, if you have a will-based plan and everything is going through the will, then that requires court to work. So in a will, you're going to name personal representative, which is known as an executor in other states. Arizona had to be different, so I think we're one of the only states that calls it personal representative. Designate distribution of property in your will, directs payment of debts and taxes. So when you have a trust-based plan, and I'll get into a trust versus a will as well. When you have a trust-based plan, you also have a will. It's called a pour-over will, and the idea is it pours anything that's outside of your trust that wasn't funded into your trust upon your death. And again, you want to try to avoid going through that process if you have a trust set up, because most people who have trust want to avoid probate. Even if you have a will-based plan, you can set it up usually you can set it up in a way where you can avoid probate by having assets with beneficiary designations going directly to your beneficiaries. But a will is always important just in case something happens. So let's say you're in a car accident. Now there's a wrongful death claim. The other person caused your death through the car accident. Now your personal representative can get authority through your will to obtain or to move forward with that wrongful death claim and then gather the assets and distribute them according to the will. So even if you have all of your beneficiary designations set up on all of your accounts and your assets, it's still important to have a will set up. Within a will, if you have any guardian or if you have any minor children, you can name a guardian. You can also name a guardian for an incapacitated unmarried adult child. So if you have a special needs child who's an adult, within your own personal will, you can specify who you want to be guardian if something were to happen to you. And another thing that's really important that most people don't know about is you can name a guardian for an incapacitated spouse. So let's say your spouse has Alzheimer's dementia, they're incapacitated. Within your own will, you can specify who you want to serve as guardian over them if something happens to you. So very important if you're in that situation. Now a trust. So I like to tell my clients, think of a trust like a bucket. And all of your assets that we can put into that bucket now while you're alive, essentially your successor trustee will step in and manage those assets within that bucket. Trusts are a little bit easier for incapacity planning because of there's less of a risk of a bank not accepting a successor trustee versus a power of attorney, which I had mentioned some of the issues with before. So the trust would control assets if you have a trust and the assets are named in the trust. If they're outside of the trust, then the power of attorney controls those assets. Within the trusts have a lot more flexibility. So if you're wanting to do specific, maybe you have a special needs beneficiary and you want to make sure that they don't get kicked off their government benefits if they receive an inheritance after your death, then those are instances where you can have protection in place through a trust versus a will. Usually you don't want to have those types of protections through the will. It's a lot more complicated. It has to go through the court process. So as I was saying, for trust, during life, it's greater for incapacity planning. And you're putting in instructions, very specific instructions in your trust for how you want your assets to be administered during your life if you become incapacitated. So do you want them to be administered only for your benefit or also for the benefit of you and your dependents? So those are all different considerations you would want to think about when you're setting up your trust, because you can have different specifications. And then at death, your trust is irrevocable, so meaning unchangeable. And so the trust basically provides instructions for how you want your assets managed and distributed, specifies who you want to receive your assets. And like I was saying before, trusts are a lot more flexible. So a lot of times when there's concerns, so if you're married and you're concerned about your spouse changing your estate plan after death and disinheriting your children, which we actually do see happen quite a bit, then you can have certain remarriage protections in place. So it's not to prevent the remarriage, but it's to protect your children, your beneficiaries, and also your surviving spouse. So let's say your surviving spouse has some capacity issues and a caregiver swoops in and tries to take advantage of that. There can be protections in place through the trust that can make sure that the assets are there protected for the surviving spouse, and then that they go to the beneficiaries upon your death. So that's something that's important to think about. If it's important to you, then you're looking at probably more of a trust-based plan versus a will-based plan where everything goes out right. You can also have protections for your children. So the way we do our planning, we do beneficiary trusts within our trust. So after your death, it goes into separate, think of them like safes for your beneficiaries, accessible by the beneficiary. And most of the time you have, most clients will have, let's say it's to their children. They'll have their children be the trustee of that trust. So they'll be managing that beneficiary trust, but it will be protected from things like divorce. So if they get divorced from their spouse, now it's protected. If they get sued, if they open a business and they file bankruptcy, it's protected from those types of things. So a lot of times it's a really good gift to leave to your children. If you have minor children, it's also an easier way to allow for someone to manage those assets for the minor until they turn a certain age. So like in my situation, I have a 5-year-old. My beneficiary trust specifies that she can't be her own trustee until she's a bit older. So I think we've gone back and forth, but somewhere 25, 30 is usually what we're generally recommending. And then as she gets older, that'll get adjusted. And so the idea is you want to make sure that the assets are protected for that beneficiary. If there's any kind of special needs, like I was saying before, the trust can basically protect the assets so it supplements the beneficiary's care and prevent the beneficiary from losing government benefits. So like if they're receiving Medicaid, All-Tex, Arizona long-term care, you want to be careful about leaving them an outright gift because then they could get kicked off of those benefits. So some practical considerations whenever you're looking at trust is, so one of the most important things is nominating who you nominate as successor trustee, and you have to make sure that you trust that person. And there's differences for incapacity and upon your death. So if you wanted someone to manage, so let's say you have a child who you would want to manage the assets for you if you become incapacitated, but upon your death, you don't necessarily want them to administer the trust because maybe they have some conflict with another sibling who's also getting money. So you can have different successor trustees for incapacity versus death. And like I was saying before, it's always good to have multiple successors in place. We also are lucky to have some professionals who work in Tucson who act as professional trustee. So there's always that option as well. That's usually beneficial if you think there's going to be a fight among your children, or you don't want your children to be in charge, or maybe they don't get along. Sometimes clients with a lot of real estate, they'll want a professional to step in. That way the kids aren't having to deal with selling all the real estate and managing that aspect. So different considerations. So like I was saying before, it's always important to have a list of all of your assets. For trust-based plan, it's very important to make sure that your trust is properly funded. If it's not funded properly, meaning the assets are within the trust, either while you're alive or going into the trust upon your death, if it's not funded appropriately and there's an asset outside of the trust, then a probate may be needed. So now you're having double administration, probate and trust administration. So it's always important to just review your funding. We recommend every couple of years as well with our clients to take a look at that to make sure everything is appropriately funded to your trust. For a will-based plan, so if you're doing a probate avoidance plan through a will, it's always good to work with your attorney and make sure that your beneficiary designations are set up properly to try to avoid probate, and also to revisit that. So just a good idea to look at these documents every couple of years. So a few potential problems if you don't have an estate plan in place. So let's say you're not legally married to your significant other. So in Arizona, Arizona doesn't recognize common law marriages. So if you're not legally married and you have no estate plan in place, your significant other would have no right to your property. So that causes a lot of issues. So something to think about if let's say you're living with someone, you both are on the deed to the house, something to consider if you're not legally married. So under Arizona law, if there's no surviving spouse, the entire estate passes to the decedent's descendants. There's no descendants, then there's a whole chain of who it goes to, and the partner is not someone on that list. So it would eventually go to the state of Arizona because the partner has no priority unless you have an estate plan in place. Also, they have no decision-making rights. So let's say you're in an accident and someone needs to make a decision about treatment, they wouldn't be able to make those healthcare decisions without going through the process of being appointed guardian. And they also wouldn't necessarily have priority to become guardian. So it's just important to have a healthcare power of attorney in place if you're in this type of scenario. They also wouldn't have the ability to make financial decisions during your incapacity or make funeral arrangements at your death. So if you or you know someone in this situation, it's very important for them to have an estate plan in place. Blended families. So with blended families, we run into a lot of issues. So it's always important for a blended family to have an estate plan in place. If there's no estate plan in place, not all property transfers to the surviving spouse. So if the decedent is survived by a spouse and has one or more children from a relationship other than with the surviving spouse, the surviving children get decedent's half community property and half deceased spouse intestate separate property. So this is a shock to a lot of people. So I just want to highlight this. If you're in a blended family, it's so important to have an estate plan in place. That way you can avoid being in a situation where a surviving spouse has to share what they thought would be their assets with stepchildren. And so I promised I'd leave a lot of time for questions.
So thank you, Shanelle. So I have a question. Sometimes we hear about something called a Miller's Trust.
Mm-hmm.
Can you explain what is a Miller's Trust? Like, when would that be used?
So a Miller's Trust is a special type of trust that's used when someone's trying to get on Arizona long-term care, in basically the state's Medicaid. So a Miller's Trust, so there's 3 different requirements for someone to get long-term care. So there's medical necessity, so they have to meet certain medical qualifications. There's income requirements, so they have to be receiving under a certain amount of income to qualify. And there's an asset requirement. So if their income is more than the required amount through Arizona's state law, then a Miller's Trust can be set up to allow for the extra income to be funded into the Miller's Trust so that the individual can still qualify for all tax.
Okay. And that's great. That's good to know. What is the typical or average cost to set up, to do a trust setup, somebody is asking, and how often should it be updated if no major purchases have been made?
Sure. Yeah, that's a great question. So So for our office, typically how we work is it's a $400 consultation fee. And so that's where we go over in detail the different options, whether you need a trust versus a will, what makes sense for you. I like to go over both options. That way you can make a determination of what's important to you. Typically for our trust-based plans, they're somewhere around $5,000 to $6,000, and we deduct that $400 consultation fee. So we're probably mid-range in terms of fees. You could probably find you can find less expensive attorneys, and you can find more expensive attorneys. So we're somewhere in the middle in terms of setting up the trust. For a will-based plan, it's usually around $1,800 to $2,500, depending on what's needed. So $2,500 is when we're doing trust within your will. A lot of times, most people aren't doing those types of plans, so it's going to depend on what you're needing. So that's average for our office. Like I said, we're mid-range, so that it varies with other attorneys.
Okay. I had another question come in that asks about what happens if the person you listed as your guardian or your POA has passed away and you did not update the information. So they're no longer able to make those decisions and you are no longer to make those decisions. Who does it default to?
Great question. So this is why I highly recommend having multiple people listed. That way, if one person dies, then it goes to the next. Whoever you list, they never have to serve. So it's up to them at the time to make that determination. So that's why it's good to have the succession. If you don't have successors listed, now if it's healthcare, now a guardianship would have to be set up through the court. So the court would appoint a guardian, and that's going to depend on who petitions, who has priority.
Okay, all right. So it wouldn't be, I know oftentimes for medical things, they have a sort of an order that they follow, right? To try to help out, right? So that you can sort of go through that list.
Right. Yeah. For medical, you have like a different priority. And also there's the surrogacy statute. So it's kind of up to the hospital if they're going to accept the surrogacy statute in that scenario. And it kind of depends on the scenario. Let's say the surrogacy statute doesn't work. Now we're defaulting to guardian. So the court would be appointing a guardian in that. And there's a certain level of priority as to who can be appointed as guardian. So like spouse, then children. So there's a different list of priority in this.
Right, and it just sort of goes down that list. Okay, great. That is all the questions that I have that's come in online. I am going to wrap up with our online audience, and I'm going to turn it over to you to speak with the audience that's there in person. I want to thank you so much for being here, Shanelle, and for providing us all of this information. It was great.
Of course. Thank you.
Thank you. Thanks for being here today. We look forward to having you back. Our next presentation is going to be on Wednesday, April 30th for Prices May Vary Funeral Options. That is Wednesday, April 30th at 10 a.m. If you're interested in that class, please give us a call. We'd be happy to get you registered. The phone number is 520-324-1960. I also know that Shanelle mentioned that we do have help here if you are looking to complete your medical advanced directives. We have a volunteer that that comes to our office. If you would like to have an appointment for that, it is free to meet for an appointment. The phone number again is 520-324-1960, and we'd be happy to get that set up for you. Thank you again for being here, and we look forward to seeing you next week.